Good afternoon, students. In this conference, we will see the following chapter. 2. Tort liability. If the contractual liability finds its source in the non-execution of a contract, whose consequences were intended by the parties, the tort liability relates to all events and actions existing outside of any contract and which may give rise to damage involving reparation. The cause of liability tort being diverse and vary. The civil codes distinguish between different cases which come under personal fault but also the fault of others as well as the fault of any specific object or even of an animal. A characteristic of tort liability. The condition of tort liability, in the same way as for contractual liability, the implementation of tort liability presupposes three fairly similar conditions: damage, a generating event, fault, and a causal link between the fault and damage. The nature of the damage is identical to that of contractual liability. It can be material, bodily, or moral damage. Examples are numerous and can result for any accident, assault, or manifestation, or a will leading to endangering property or people. The damage must also be of a certain nature. A lot it might be a deprivation of luck, the candidate for a competition injured in a road accident cannot take this test. The damage must be direct. Cascading or ricochet damage is not accepted by case laws. For example, when one car hits another and several other cars arrive in turn and crash into each other, each of the driver is liable and not just the driver of the first car in the crash origin of the accident. The event generating the damage, the fault, consists of intentional or unintentional behaviors, but always reprehensible by the effect it supposes, and can be a personal fault but also the fault of third parties or even animals, buildings, or even anything in our custody, as we will see in the following paragraph. This fault constitutes the cause of the damage. The causal link appears necessary to engage the tort liability of a person. It is necessary to demonstrate this link, which consists in proving that without the generating event, the damage will not exist. 2. Exemption from tort liability. This may be an event linked to force majeure which retain the characteristic of irresistibility, unpredictability, and exteriority. A third party may be jointly liable for the damage. In this case, the fact or the fault of the third party allow a partial or even total exemption depending on the case of the person responsible. The judge will determine the liability of the co-perpetrator in order to hold them jointly and several to compensation. Finally, in the case of a fault committed by the victim himself, the exonerate of the victim will be reduced in proportion to the gravity of his own fault in the occurrence of the damage. If the possibility of legal exemption exists, contractual exemption is impossible. B. The type of liability other than the personal liability. According to the law, one is responsible not only for one action but also for the people, things, and property that one has his own charge or in one's custody. One liability for the act of other, the liability of supervision, constitute a first type of liability for the act of other. Supervisors are liable for damages caused during the surveillance they exerce on the person for whom they are responsible minor or a person whose physical or mental capacity are reduced. The responsibility of parents and teachers follow similar logic. Parents who must raise and educate their children have the obligation to supervise them and answer for their fault. Teacher, educator, and artisan are liable for damage caused by their students and apprentices. The liability of principal is based on damage caused by their agent in the function for which they employed them. 2. Liability for the things of which one has custody. This supposes three conditions: a prejudice or damage, a harmful event due to thing and our responsible guardian, without forgetting the causal link between the prejudice and the harmful event. Liability for things include three categories of liability: liability for things in our custody, as specified in Article 138 of the Civil Code; liability for animals in Article 139; and liability for a building which one owns, Article 139. Liability for things in one's custody is based on the idea that the custodian of the things must repair the damage caused. The existence of harm remains an essential condition of liability. It can be bodily injury, moral or material damage. The damage must be certain, personal, and result from a legitimate interest. The harmful event is established whether or not the thing or animal participates directly in causing the damage. At the end, for more details, I will ask you to consult the conference and the platform on PDF format.